One.
This Honorable Court of Appeals is now in session.
Good afternoon. Before we call the case, just to mention that if we don't anticipate any technology-related problems, but if we should have any such problems, just everybody take a deep breath and pause, and we will work through them. Things are working very well nowadays on this. Call the case, please, Madam Clerk.
300 Kate Street Partners, LLC versus NIS Trading Incorporated, doing business as NIS Construction.
Hear from the appellant, or from counsel for the appellant.
Good afternoon, Your Honors. May it please the court. I'm Laura Ford, and I represent the appellant, NIS Trading Inc., doing business as NIS Construction. This case involves setting aside a $1.3 million default judgment on the basis that the judgment was void. We raised two issues on appeal. The first is that the trial court erred in finding that plaintiff met its burden of proving that NIS was properly served, and as such erred in entering in a $1.3 million default judgment. The second issue is that the trial court erred in not granting NIS's motion to set aside that default judgment. I'll start with service. So pursuant to Rule 4, service by mail shall not be the basis for the entry of a default judgment unless the record contains a return receipt showing personal acceptance by the defendant or by persons designated under Rule 4 or statute. In this case, service was not proper because the record did not contain a return receipt or evidence of personal acceptance by NIS or its agent. As demonstrated by the Tennessee Supreme Court in Hall v. Haynes, the law requires strict compliance with Rule 4.
Are you disputing that NIS's registered agent was NSCA?
No, Your Honor, we're not disputing that NIS's agent is USCA.
And you're not disputing that it was sent to the appropriate address?
That's correct, Your Honor. We can't dispute that the reporting forms that they submitted had the delivery address of USCA.
Okay, thank you.
Which brings me to, at the time the default judgment was entered, the record contained only a tracking printout that it said your item was delivered to an individual. That was it. There was no green card. And the plaintiff actually admitted that the reason why they submitted this form was because the green card was never returned. This is not a return receipt under Rule 4.
Why not?
It's not a return receipt under Rule 4 because while it's not actually, the word return receipt is not defined in the Tennessee Rules of Civil Procedure, case law dictates that we need to interpret it much like statutes and apply the plain language. And if you look at the rule, it says return receipt, and this green card that I'm sure you're familiar with is the only document that is actually labeled return receipt. So we have to, strictly interpret the rule. And
so you're requiring that it has to be the green card?
yes,
and no other document? The tracking system for the Postal Service that's online is not good enough?
That's correct, Your Honor. In fact, with respect to the first printout that they submitted, the court in Dodson v. Harrington and King Perforating Company found that the plaintiff that submitted that same tracking printout, that the record did not contain a return receipt showing personal acceptance. Furthermore, the second printout was called a product tracking and reporting form. And we submit that this is not a return receipt either, based on what I explained earlier. And also, the courts have been instructed to apply the rule as written. They're not supposed to broaden or rewrite it. And there's no indication in the rules or case law that permit anything other than a return receipt.
Is there a difference in the information that's on the green card and in the tracking system?
Yes, Your Honor, there is. So the green card shows, it allows, so there's an area for the addressee, which is not on the reporting form. It has a line for both a printed name and a signature. And there's also a box for the signatory to check agent or agent or addressee. And the reporting form doesn't have it. It has the time of delivery. The second form they had an illegible signature and the mailing address, but it does not have the same things as the green card.
So an illegible signature is not the same as as a signature for receipt. I'm trying to understand what relevance illegibility means, since lots of signatures are illegible.
Well, the relevance is that the plaintiff hasn't proven that whoever that was that signed it was in fact authorized to do so. And because the record has to show that a person authorized to accept service is the one who signed it, this illegible signature, there's no way of us knowing who this person was. And so the plaintiff hasn't met their burden of proving that they comply with Rule 4.
What does the, well, I'll let that question go for your opponent. Never mind. Thank you.
So as mentioned before, the tracking report that the plaintiff submitted the second time, we do not contend that it's a return receipt. However, if this court determines that it is the same thing as a return receipt, we submit that it's still insufficient to establish service, because Rule 4 requires that the return receipt mail be addressed to a specific individual or persons in the subparagraph of the rule. And if you examine that second form closely, there is no addressee or agent listed. It just has the address. And while this may seem like a small oversight, the Tennessee Supreme Court has made it very clear that the rules concerning process require strict construction, and this does not comply with the plain requirements of the Tennessee rules. And as mentioned before, we have no idea who signed for the receipt. And there was actually a case in federal court, Trisco v. Trop Farms, where they were applying Tennessee law, and they found that there was no valid service where the plaintiff offered no proof that the name of the individual who signed the return receipt on behalf of the registered agent was an authorized subagent. And that's pretty much what we have here. Now, the trial court, however, determined that everyone at that office of USCA had to have been a registered agent. That's all that they were employed to do. So whoever it was is not important, which, there's no evidence in the record that every single person at that location was an authorized agent for service of process.
Counsel, make sure I understand. So is it your position that every time, assume there was a return receipt, if the signature is just unreadable, then it's never going to qualify as sufficient service?
Unless the plaintiff put forth any more evidence as to its relationship, yes. And we cited to a case, it was Cunningham v. Select Student Loan Help LLC, where that court, the facts are actually very similar, and it deemed that a return receipt with an illegible signature was not valid. And further, a return receipt that it didn't indicate whether it was an agent or addressee, so they didn't check those boxes, was also invalid. So when you're strictly construing the rule, it's very important for all of these boxes to be ticked. Despite the fact that Rule 4 should be strictly applied, the trial court seems to have applied a more equitable approach and found that, while the court agrees strict adherence to the Tennessee rules of civil procedure provides the most level playing field for both sides of a lawsuit. To obtain a fair outcome, a finding that service in this case was not proper would be contrary to the spirit and the purpose of these very rules. And even later went on to say, to agree with defendant and to hold otherwise would be inconsistent with the spirit in the letter of the rules. And respectfully, the trial court's desire for a fair outcome and spirit of the rules is just not supported by precedent. The law is abundantly clear that Rule 4 must be strictly applied, and the requirement of proper service of process is not some mindless technicality. The record must establish that the plaintiff complied with the procedural rules in order to confer jurisdiction, which is why the requirements that are set out in Rule 4 are mandatory and not discretionary. This very court even said that in Ramsey v. Carter, that service of process that does not meet the requirements of Rule 4 is void. A judgment based on void service is a void judgment.
Thank you, counsel. You have your time for rebuttal. We'll hear from counsel for the appellees.
Good afternoon, Your Honors. My name is Jimmy Bradshaw. I'm representing the appellees 300 Kate Street. In this case, basically the two issues involve two burdens of proof. The burden of proof on my client to establish effective service of process, and then, of course, the burden of proof on NIS to show good cause why the default judgment should have been set aside. Obviously, there's some overlap and intertwining between those two burdens, but I'd like to spend the bulk of my time talking about the effective service of process. We believe that 300 Kate Street did, in fact, establish effective service of process under Rule 4.04, the Tennessee Rules of Civil Procedure, specifically 4.04.4 and 4.04.10. As counsel pointed out, there is not a definition in the rules as to what qualifies or counts for a return receipt. There's no requirement in the rules about what sort of form or format the return receipt should be in. So we submit, and clearly the relying on the post office to return the green card to us did not happen in this case. And I'm sure that's happened in other cases. Things do get lost in the mail, but we did not receive back the green card. Fortunately, we had the ability to pull up the USPS's tracking system and provide the trial court, and now this court, with documentation that effectively establishes without question that the summons, the alias summons, and the complaint were delivered to the registered agent for service of process for NIS on August 15th, 2019, that it was accepted personally by an individual that day who signed for it. We were able to pull up on the tracking system a copy of that signature, which admittedly is illegible. But there is no question that USCA was the registered agent, and to this day still is the registered agent for NIS. And there's no question that USCA's place of business where they accept service of process is 4295 Cromwell Road, Suite 308, Chattanooga, Tennessee, which was on the certified mail form and was also contained in the tracking system printout that we provided to the trial court. Those can be easily verified and matched up with the tracking number, which is on the initial summons, green card, and the certified mail receipt. Also matches up with the tracking number that's on the product tracking and reporting forms that we provided to the court from the USPS's system.
Counsel?
Yes.
I mean, the rule says return receipt, correct?
Yes, correct.
Are you asking us to read that return receipt or its equivalent?
Well, it does say return receipt, but it doesn't specify what the return receipt is. It doesn't say it has to be, the 4x4 green card from the USPS. It has to be a return receipt, a receipt showing that the summons and complaint were served on the registered agent. And that's exactly what we've done here. In fact, I would offer to the court the product tracking reporting documents that we provided to the trial court and again to this court that are in the record not only shows that it was delivered, it actually gives a history of when it was mailed, August 13th, and as these tracking systems do, gives a step-by-step travel log of where this mailing, how it gets ultimately to its end destination on August 15th. And it says there at the bottom, this is TR 117, delivered, left with individual, 8:15, and the address is right there above it, 4295 Cromwell Road, Suite 308, Chattanooga, Tennessee. No question that that is the business address of NIS's registered agent. And again, the registered agent is listed on the Secretary of State's information. When you do a search, as my client did for NIS, you pull up the Secretary of State Business Information Services, and it shows that the registered agent for service of process for NIS is United States Corporation Agents, Inc. at 4295 Cromwell Road, Suite 308, Chattanooga, Tennessee. They are proof. Go ahead.
A proof that the person who signed was authorized to do so by USCA?
Well, so we did get into that with Chancellor Martin. The Hall versus Haynes case, which this court, I'm sorry, not that, the Herring versus Interstate Hotels case, which this court decided in 2000, is a similar issue. The registered agent in that case was CT Corp, which, you know, we're all familiar with. And the person at CT Corp that signed to accept the summons and complaint in that case was simply listed as M. Hall. And the Court of Appeals in that case decided that was sufficient. The plaintiff did not need to go into any further detail, any further proof to establish that M. Hall was had to be some sort of subagent of CT corporate systems. The record here, as the record did in the Herring versus Interstate Hotels case, shows that this summons, alias summons and complaint were delivered to the address, the specific address of the registered agent, and that an individual at that address accepted it and signed for it. USCA, go ahead.
It would be your position that rather than you having to prove that the person was a agent of the corporation, it would be incumbent on your opponent to prove that they weren't.
Yes, sir. That is should be part of their burden of proof. We met the requirements of Rule 4.04. We served the registered agent. Somebody there accepted it on behalf of the registered agent, and that's what the Rule 4.04 requires. Now, if for whatever reason NIS wants to show the court that no, USCA was not our registered agent, or they were not at this address, or that this individual, whoever signed for it, was not a person working at USCA, then it's incumbent upon them to come forth with proof to show the court, that would be the good cause shown to set aside the default, to show the court that those in fact are the case. They didn't do that here. This is their agent for service of process. USCA is their agent. They've represented that to the Secretary of State. They've published that on the Secretary of State's website. They are required by statute in order to conduct business in Tennessee to have a registered agent for service of process.
Mr. Bradshaw, did
Yes, sir.
the registered agent provide an affidavit saying that they never received this or that they do not have anyone by this name that's authorized to receive service of process?
Not in this case. No, sir. No, sir. All we have in this case from NIS is a self-serving affidavit from the owner of the business saying that he never saw the summons or the complaint. Now, that may be the case, but then he has an issue with his registered agent for service of process. As Chancellor Martin pointed out, the registered agent for service of process has a contractual obligation with its client, in this case NIS, to accept service and then to report that immediately. That's their contractual duty.
And they could have provided an affidavit saying, we have no record of it ever being delivered, and whoever this person is not authorized to receive service process, and they didn't do that.
Yes, that is in fact the case. In fact, I've been in this situation before in other cases where I had a client who had CT Corp was their registered agent. They allegedly were served through CT Corp, but we were able to go back to CT Corp. They were able to pull up pretty meticulously kept records about what comes into their office and who signs for it. And they were able to establish that they never got the document that the other side purported that they served on CT Corp. Seems like that would be one of your first steps if you were going to show good cause to set aside the default. And that hadn't happened here. They have not provided any information from their registered agent that the registered agent did not receive this, or for whatever reason, failed to convey it to the principals of NIS.
Another question about the tracking form. The form has the address of the registered agent. Is that right?
Yes, sir.
Does it have like the name USCA on it, or does it just have the address?
The tracking form, I think, just has the address. I would submit that the documents need to be read in toto. So we submitted what's the USPS tracking with this was attached to the return of service, the USPS tracking in lieu of the green card, which has the tracking number. It also had a photocopy of the certified mail receipt that the sender, keeps, which mirrors the tracking number, and that has NIS Trading Inc. Then the rest of the card was filled out with the specific address of the USCA office in Chattanooga. So the address is on there, but again, in order to establish the return of service, or the actual service of process, these documents need to be read in toto, just like they would be if you had the green card, which would be read in connection with the summons and any other document that needed to be submitted. So,
and your tracking document gives the exact time of day that it was delivered by the Postal Service to the registered agent.
yes, sir. August 15th, 2019 at 1:38 p.m. So it actually, the tracking reports from the USPS give actually more detailed information, more reliable information, I would submit, than a hand-filled out green card. So that is correct. So we would submit that in this case, 300 Kate Street met its burden to establish effective service process on NIS by use of these USPS tracking reports. And again, through no fault of 300 Kate Street, we did not receive back the green card. But I think there should be an allowance under the rules. And I think, in fact, there is room under the rules for an allowance under the rules to include within the scope of a return receipt the USPS tracking reports. They're used in other walks of life, in business. They're a reliable source of information. Clearly, Chancellor Martin had no problem in relying on the USPS tracking reports as an authenticated document from a public agency like the post office. So we believe we met our burden to establish the effective service of process on NIS, which then I think would shift the burden. We complied with the rule, and once we show we've complied with the rules, the burden should shift to NIS to show good cause, if any exists, why that service was not effective and why the default should be set aside. And here NIS failed to meet their burden. All they've submitted in essence is a self-serving affidavit from their owner stating that he never received the summons or the complaint. And if that's all it took to get out of a default judgment, then that would be a pretty easy process for anybody to get out of a default judgment. Just submit an affidavit saying you never got it, and the court would have to set aside the default judgment. That's not the law, though. We have established substantial compliance with Rule 4.04, and a affidavit simply saying that he didn't get it is not going to be enough in this case. They should go the extra step. They should have provided some sort of documentation, some sort of declaration or affidavit from their registered agent who is under a contractual duty to provide this information to NIS to clarify whether or not this actually happened or to somehow contest it. The fact that they didn't should speak volumes to this court that, in fact, that doesn't exist. NIS was served through the registered agent, and therefore they have not been able to establish good cause to set aside the default. So we'd ask the court to respectfully find that the service of process was affected on NIS through the registered agent, and that NIS failed to establish good cause to set aside the default and deny this appeal. Thank you.
Counsel, I want to ask you a question before you
Yes,
go
sir.
here. Where on the USPS does it have the address, the USPS tracking?
So if you look at TR 117 in the record, the 117, there's a box about halfway down the page called tracking number classification. It says class service, destination address 4295 Cromwell Road, Suite 308, Chattanooga, Tennessee 37421.
All right, there's another USPS tracking results. Okay.
Yes, there is what Ms. Ford referred to as sort of the first document that was attached with the return of service that we filed when we got it back, which it just says USPS tracking, and it's got the tracking number at top, and it's got a photocopy of the certified mail return receipt, and it shows that it was left in Chattanooga, Tennessee.
But it doesn't show the address, does it?
But that doesn't show the address, but the more detailed report, which is also in the record, does in fact show the address. It's just a matter of drilling down on the tracking system website to get the specific detailed information.
All right. Thank you.
Thanks.
We'll hear from the appellant in rebuttal.
Oh, you're on mute.
Counsel.
Okay, sorry. With respect to Herring, the issue before that court was not whether or not service of process was valid, but rather did the trial court err in not granting that defendant additional time to answer? So I think that saying that that court held that M. Hall was sufficient enough is just not a proper conclusion. It was not a determination of law made by that court. Furthermore, counsel said that the tracking reports are more reliable. Reliability isn't necessarily the issue here, but those forms don't contain more information, as I pointed out earlier. There is not a spot to print because, like, often, signatures are illegible. There was no spot to print the name. There was no box to check whether this person was the agent or the addressee. And in fact, I believe it's on that same page of the record, TR 117, there's actually a spot for agent information and it's completely blank. And in order for plaintiff to meet its burden that service was proper, they have to comply with the rule. He made the comment that they have substantially complied with Rule 4. There is no case law that says substantial compliance is sufficient. It says over and over again that strict compliance is required. And as far as the burden goes, yes, we have the burden of proving that we're entitled to relief, but the plaintiff has the initial burden of proving that service was proper to begin with before a default judgment should have even been entered. And we have met our burden of proving that the $1.3 million default judgment should be set aside. We've cited authority directing this court to strict compliance of Rule 4 and demonstrated that the record does not contain a return receipt. And even if that tracking report is in fact considered a return receipt, which we contend it's not, it fails to meet Rule 4 as it does not set out a specific addressee. So that in of itself, it has not complied with the rule. And therefore,
are there any cases that in which another service besides the Postal Service, say, FedEx, has been used for service of process?
no, Your Honor, I'm not aware, and I never came across any cases that used any other form or business to deliver these.
Where in the rule does it say strict compliance as opposed to substantial compliance?
In the rule, it doesn't use that exact language, but the Supreme Court has stated that strict compliance is required. And it says, I'm sorry, go ahead.
I said, okay. Okay, thank you.
But the Supreme Court has said time and time again that strict compliance is required. And I'm sure you are all aware that default judgments are not favored by Tennessee. There's a clear preference for a trial on the merits, and considering the size of the judgment here, this case should be sent back to the trial court and be allowed to proceed on the merits. And additionally, courts have been advised that if there's any reasonable doubt as to whether or not a motion should be set aside, that the trial court should have exercised its discretion in granting the motion in favor of setting aside the default. So with that, the appellant respectfully requests that the court set aside the $1.3 million default judgment entered by the trial court on the basis that it was erred in entering it, or on the basis that the trial court erred in not granting NIS's motion to set aside.
Thank you, counsel. Thanks to counsel for both sides. We appreciate your oral argument today and your briefs on this. Madam Clerk, if you would please adjourn court till tomorrow morning.
This Honorable Court of Appeals stands adjourned.
Thank you.
Thank you.